and opportunity.
I'm Chris Richardson, and this is Not a Pipe podcast. Thanks for listening today. I'm happy to be speaking with professor and legal expert Brian Tamanaha, who has written A Realistic Theory of Law, an important work that I think is relatively accessible for anyone like myself who isn't specializing in legal theory or law, but also an important work because it takes us back to the beginning of law, where we've come from, and possibly where we're going as a society. So it helps answer some timely and important questions while also giving us a broad perspective on things that we might not have thought of otherwise. So Brian, thank you so much for being on the show today. I really appreciate you taking the time. Let's get right into it and start with what is a realistic theory of law, and how does that differ from analytical jurisprudence or natural law, for example?
A realistic theory is set out by way of contrast to the two main schools of theory that dominate currently. And one is natural law theory, and the other is called analytical jurisprudence. Natural law theory is focused on objective principles of right and the relationship of positive law to those principles. Analytical jurisprudence is focused on questions of the nature of law, the essence of law, the core features of law, and that analysis is very abstract. The realistic theory, on the other hand, is based on bringing an empirical perspective to law, looking at what law is, what law does in sociological terms, in historical terms, anthropological terms. And I wrote the book because there was a significant lack of theoretical work on law from this more empirically based perspective.
Yeah, I found it was really interesting how you do highlight that historically there has been these three approaches, but the realistic theory has sort of dissipated in terms of popularity or the way people are thinking of it today. Why do you think that is?
Yeah, that's right. It fell away really after about mid-century. In jurisprudence, it's actually a thriving perspective of law outside of jurisprudence. Empirical studies of law have really been booming in recent years with the growth of the Law and Society Association in the United States and really across the world. The problem is that jurisprudence has become, jurisprudence that is legal theory, has become increasingly insular and abstract over time. So it basically shed this perspective. And it's difficult to explain exactly why it happened, but I would say a major contributing factor is that legal theory over time has been increasingly influenced by philosophical concerns. That is, people trained in philosophy began doing legal theory and brought a particular version of philosophy, that is an analytical approach, which then ultimately became defining of legal theory. And I think that's unfortunate. And it's not because that isn't an important perspective. It's because that perspective can be developed without discarding this third empirically based approach. I'll add one other aspect to that, and the impact of institutional support. I believe what helped analytical jurisprudence rise to this position, and it's far more dominant than natural law theory. But what helped it rise to this position is that it secured strongholds in Oxford and Yale. And this is the way knowledge developed. People in the most prestigious institutions then had doctoral students and students who followed their path, and that became a way of perpetuating this particular point of view.
I mean, you highlight this really well in the book, but especially for anyone who hasn't yet read it, why is that a concern that, why haven't we just simply adopted this analytic approach or a natural approach? Why are those insufficient?
Well, the main problem, and each is important and yet has limitations. So the natural law theory, as I said, focuses on objective principles of right and its relationship with positive law. The primary influence of that is Thomistic natural law theory. There are other versions of natural law theory, but all of them have that as their core focus. And there's much more about law outside of that. That's one problem. The other problem is it presupposes that objective principles of law actually exist and can be identified. And these are very controversial issues. So the problem with natural law theory is it has a very specific focus, and anything outside of that focus is not taken into consideration. And there's a similar narrowness to analytical jurisprudence. It's very abstract. For example, one philosopher, a very prominent one, wrote that sociological approaches to law can't inform general jurisprudence because it's limited to human societies, and philosophical approaches apply to alien planets. So this is what I mean by a very abstract approach. If you're focused on essentialist concepts, what you have to do is pare away all of the aspects of law that operate within society, because every society is unique. That's one problem. If you focus on essential features, you can't talk about history, because history is taken out of a perspective like this. So they are seeking out the essential features of law in all places and all times. And when you have that kind of an approach, you can't actually talk about how law develops over time, which, as you know, is the focus of my book. So the basic problem is that each has its own particular, very narrow and ultimately abstract orientation. And from a theoretical standpoint, this leaves out really fundamental issues about what law is and what law does. And let me give you one more specific example. Analytical jurisprudence write about, for example, the essential features of the rule of law. But what they can't tell us is how a rule of law develops within society. And that concern is a concern to many people working in law development, as well as many theorists. They can't talk about the plurality of law within societies. And many societies have multiple legal systems because they're focused on the essential nature of law, which presupposes that there's only one thing that counts as law. So owing to their philosophical orientation, many important aspects of law today, things that people care about, are not taken up.
You do highlight how, in a general way, we can look at all three or from all three perspectives for a fuller account of how the law works and how our societies work. But when pushed, they can seem to contradict one another. For instance, if in societies that have recently chosen to change one law from, I don't know, anything really, but to legalize something that wasn't legal before, we can clearly see social influence. But then that seems to contradict that there's a natural law in which there should be a right or wrong inherently. And I'm wondering if you can say more about how we can use these ideas or these perspectives without inherently sort of contradicting ourselves if we try to put them together.
These three approaches are different. They bring different angles, different approaches, orientations to law. And in that sense, there's a tension between them. They're also complementary in the sense that a full understanding of legal theory would take account of all of them. I apply this realistic approach to understand natural law theory itself, the emergence and development of natural law theory, the development of analytical jurisprudence. But you're right to say that on certain issues, there's a tension between them. The extent to which that tension becomes problematic depends on what matters to a particular person. Natural law theorists, I don't think, particularly care about an empirical orientation to law in the sense that I'm trying to develop, because their primary orientation is about working out a theory of natural law. But they do bring this theory to bear on contemporary issues. So, for example, two of the most prominent contemporary natural law theorists, John Finnis and Robert George, have written that marriage is a basic good of law, and that have taken this position, which they develop in natural law terms, and have taken this position to say, therefore, that homosexual marriage is antithetical to natural law. So they do apply it, but this is based on their own grounding in natural law theory. I don't know that there's a direct conflict between their approach and my approach. I'm just suggesting that theorists in general, if they want to understand law, should have awareness of all three perspectives. But I don't take them on in a fundamental way in the book. I spend the bulk of the book articulating what a realistic perspective tells us about law. The objective of the book really is to set out an account of what law looks like from this perspective. And the main objective there is really to develop a vision of law in social historical terms. Along the way, I critique primarily analytical jurisprudence because they make assumptions about the essential features of law, which I believe do not hold up. So that's another respect in which you're correct, that although I say they can complement one another, there are specific points on which there's fundamental disagreement. And I'm basically arguing that they're wrong.
Well, I'd like to hear a little bit more about that. Maybe we can apply it. One of the things I was thinking about, just because I've been recently reading this, the Kavanaugh hearings, for example, bringing someone into the Supreme Court has been a huge media issue. I'm not necessarily asking you to weigh in on that particular event, but for me, it brought up this idea of whether or not law is impartial, because if it's impartial, then who cares who's doing it as long as they're informed. But obviously, a lot of people feel that if someone is brought to the Supreme Court from a Republican or from a Democrat, that's significantly going to change it. And I'm wondering if you could just say a little bit about how someone watching the news or reading about this process, for example, can use a realistic theory of law to maybe unpack some of that debate that's going on.
Just as a fundamental starting point, one of the points I make about law, and as I said, I do this through a genealogical approach, taking a historical perspective on law, which is that law has two sides. On the one hand, it serves essential, fundamental functions within society in relation to ordering social intercourse, doing all sorts of things. So that's one side. The second side of law is that law is thoroughly, completely influenced by social, economic, political hierarchy within society and influences it in a variety of ways. And this is true from Hammurabi's Code, which was replete with status distinctions, to law in the United States today. And we can see this at various times in history. It's a constant of law. Law is not neutral in that sense. Law is itself the reflection of battles within society. And these battles are carried out on a continuous basis. And these battles are actually a source of legal change. Law changes, we often think of law changing in terms of legislation, but law also changes through judges, through decisions that judges make. The Constitution hasn't been amended in a long time, but constitutional interpretation has changed over time. And it's changed over time because the people who occupy judicial positions bring different views, both about how the law should be interpreted, but also background views about the political theory that should inform legal interpretation, and even more specifically, background views, as in some are Republicans and some are Democrats. Now, they're not voting on judicial decisions as Republicans and Democrats, but they're bringing their background perspectives to the cases when they decide them. The key, I think, is to understand that this is inevitable at a certain level because rules fundamentally require interpretation. But it's not pervasive in the sense that it applies everywhere and at all times. And when we talk about the Supreme Court in particular, we should keep in mind that these are the most hotly contested cases. And even then, a significant number of Supreme Court decisions are unanimous or 6-3, 7-2. It's when you get to the really hot button salient cases that we get 5-4 decisions based on what looks like, and I think accurately, background political perspectives.
How do you recommend somebody consider this when, to me, the interesting thing that I've been particularly looking at are the media discourses around making decisions, who would be a good judge, for example, what laws ought to be there, and in a general way. So I'm not talking about, of course, lawyers debating, although they weigh in a lot, but I'm talking about the more general public debates that are going on. It seems like there are two competing and potentially contradictory understandings. The legal system is supposed to be unbiased, but on the other side, we're talking about the biases of all these people, and I think if I understood you correctly, you agree that this bias is never going to go away. So should we stop thinking of the law as unbiased, or is there another way to negotiate these questions of perspective and of bias? I don't know if that's the best term, but it seems like we can't possibly believe in a fair legal system that is unbiased, but also believe that anyone, judges, lawyers, anyone participating in this system is always going to bring their biases. So I'm curious how you would recommend thinking about it.
Okay. So I want to talk about it just a little bit differently.
Sure.
I wouldn't describe the legal system as unbiased writ large, the legal system. The legal system, the norms represent, on the one hand, norms of the community, on the other hand, fundamental relations of property and marriage, divorce, obligations, contracts, things like that. On the other hand, the law represents specific forms of legislation, for example, the Affordable Care Act. Now, these are policy decisions. The law is changing all the time and changing along with changing social views, but it's also changing in relation to effective exertion of power over political decision makers who legislate. So if you have a strong lobbying economic interest can achieve outcomes that they want, those outcomes are not unbiased. Those outcomes are a function of particular coalitions that seek outcomes in legislation and then pursue them and do so in ways that are effective. Now, often these outcomes are justified in terms of the common good, but nonetheless, the interests seeking them are also seeking them for their own purposes. So lots of law is produced in ways that are just consummately influenced by political, social, economic interests in various ways. Now, that's creating law. Now, the second point is applying the law. And this is where I think the description that you're using fits more particularly. So when judges apply the law, the idea is that they're supposed to be unbiased. That is, not to favor one side or another, but to be neutral decision makers who apply the law as written to the situation at hand. This is the fundamental idea of the rule of law. In many cases, the application of the law is straightforward, right? If there's a speed limit and did you go 55 and you were clocked at 65, okay, and you violated the speed limit. In other cases, the law is more complicated. Some provisions, for example, have unjust enrichment, duress. These are situations that require some level of interpretation, and that interpretation inevitably comes with background influences. At that point, it's still not clear that this is a matter of being biased. What it is a matter of the ultimate reality that words and rules need to be filled in by people who interpret them. Rules are not self-interpreting and self-applying. And there is a significant region of uncertainty and openness in rules. So the realistic perspective on law is that this is just in the nature of laws, language, the application of law, human decision-making. They can't be eradicated. Now, let's raise to the ultimate question. So does that mean we can't have a rule of law system? And for me, the answer is no, we can't have a rule of law system, because the question is compared to what? There are societies in which judges are not just interpreting based on their background views in situations of gaps or uncertainty, but they're actually ruling for one side or the other based on bribes, based on directives from political authorities, or based on simply favoring one position. Now, that is not a rule of law system, because there the laws having very little role in the decision making. In our system, law has a significant role in the decision making. You might say it sets the general parameters of the decision, and only when indeterminacies and uncertainties arise do these other factors come into play in judicial decisions. But we have many empirical studies that show that certain judges rule in employment discrimination cases more often for defendants than plaintiffs, and so forth and so forth. Now, they're not pervasive, but there are differences at the margins depending on the background views of the judges.
Let's think a little bit more, I guess, in a large historical picture, which is something you highlight early on that's, I think a lot of us know or sort of understand intuitively, but it's really, to me, it's really interesting to think about how much things have changed in terms of societies and civilizations. Of course, during hunting and gathering, there wasn't a lot of concern about property law and that kind of thing. As we acquired more property, more differences in terms of what people had and how much physical property they maintained, then of course we get into different kinds of legal systems. And then with complex organizations in the last 100 years, it's been, one could say alienating from the individual, but also just much more concerned with groups, corporations, society as a very complex system.
Right.
Where do you see the changes in the law most recently? And if anything, what do you think ought to be changed or will be changing, especially as we work more with digital technologies and with these kinds? I mean, I know that the internet in particular is a source of debate when it comes to law. What are the changes that you think are most prominent, I guess, today and tomorrow?
Well, as you suggest, the book is about laying out how laws changed, evolved, developed, become more complex over time. And the last part of the book is about the specific consequences of the rise of organizations, both private and public. And I should say, actually, even the distinction public-private don't actually work, or is not as clear-cut as they were before. It's one of the points I try to make is that private entities are now themselves taking on legal functions in many ways, and this bears on what you're talking about. So there are many changes on the horizon, and it's very hard to see exactly what will result. But I think one of the implications of what I talked about is there's tons of law ex ante. All of our relations are pre-established in terms of what I call a relatively fixed legal fabric. And this relates to everything we do, from getting a credit card to taking out a phone. We don't actually negotiate the terms of those arrangements anymore. We just decide whether we're going to get a phone, but if you get it, you have to get it on the terms pre-established by the phone companies. So we have developed in modern society what I call a relatively fixed background legal fabric that all our transactions take place against. Problem is, if something goes wrong, you don't have access to legal institutions, partly because of costs, partly because we're now sent to arbitration, which, by the way, is private arbitration. That's what I meant by no longer having sharp distinctions between public and private entities and functions. And then now we have other things going on, which is automated participation in policing, from a simple thing like cameras at stoplights. But now automated searching for big data surveillance. We also have recently developed algorithms that specify risk factors for people being considered for parole. So lots of things are now being taken over using increased computing power. One of the most interesting studies for me recently was a study that had a decision-making algorithm that predicted the outcomes in tax disputes, or retrodicted, accurately to a point of above 90%. Now, one of the implications of that is that if they can predict to such a high level, then clearly they can make decisions. So it seems to me, with the rise of mass society and the numbers, part of the reason private entities are undertaking so many legal functions, and now I mean private entities as well as computerization, is simply the numbers in mass society are too high. We have early 20th century institutions, a judge sitting in a court, but we have now many more, a multiple of many more times transactions. So the future of law, I think, clearly is moving in the direction of greater automation, greater decision-making through algorithms. We already have significant e-discovery, document review. These are computers looking through documents, highlighting keywords, and these jobs used to be done by individuals. Now, there's a limit to how far that can go, but the point is we haven't reached that limit, and more of it is being automated. So I don't know. What I do know is that this is not just a trend, but one with significant implications for how laws carried out, how laws constructed, and it's going to continue with increases in computing power and the gathering of big data.
I'm glad you brought that up, because I wanted to ask you, I've had people on the show, and I'm having people in the future on the show who have talked about algorithms and their benefits as well as their sort of inherent biases. It seems that sort of one group of people, if you want to divide it in a really simplistic way, one group of people think that algorithms, for example, machine learning, will help make laws more just, or the practice of law more just, because it won't take into consideration things like judges' opinion, judges' maybe unconscious biases towards race, class, gender, what have you. It will follow the law to the T as much as possible, except perhaps in these situations, like you mentioned, where it is very complex and needs somebody to weigh in. So there's a lot of proponents of computing in the legal system, but then there are others who say that we've actually done studies that have created arguably racist algorithms because we fed in all of these histories of the decisions, and the decisions tended to weigh against people of color, for example, and so these algorithms are inherently ruling against people of color more frequently because that's what they were trained on. Are you more sort of optimistic or pessimistic about the use of algorithms and machine learning? And maybe you can say not whether you necessarily endorse them or not, but what are the implications? Because we seem to have, the perfect objectivity, but then we also seem to have machines that can execute perfect racist decisions based on histories of racism or something to that effect.
So first, I'll say that it's inevitable, and I think it's important to have that starting point. This is not just happening, but it's going to happen, and at some level has to happen. And this is simply just a matter of the capacity of our system to process the numbers of situations where there needs to be some kind of legal decision-making done, and we just can't do it. We don't have the institutional capacity or the resources to do it. So let me just give you one example. Europe has or passed that right to be forgotten law. And Google has been the primary processor of these cases. I found one study that said in a 2-year period, they made decisions on 400,000 requests.
Wow.
We just don't have the institutional ability to do it. So this is what I mean by it's not just inevitable because in some ways it's more cost efficient. It's inevitable because there's no other way to do some of these things. Now, given that it's inevitable, in response to your question about the two choices, those who think it's going to be great and those who worry about it, I think they're both correct. They're correct in the sense that it will be more efficient. It will allow many more decisions to be made that otherwise would go wanting. On the other hand, there are real risks involved, and that just depends on what's put into it, what kind of information is analyzed, and some of that information will simply have biases built into the formula, and it will play out in ways that are unfair. So both sides have to be paid attention to, and to the extent that the algorithms can be adjusted to account for these biases, then that's the value of critics raising these points. Being aware about that potential, I think, is a fundamental first step. Ultimately, the biggest issue of decision-making is whether or not there'll be an opportunity for me, an opportunity to appeal. That is, there will always be exceptional situations. It's in the nature of rules that they're going to be applied to situations that the rules didn't anticipate, the outcome would be fair, that any human being exercising judgment would believe is not fair, not appropriate. If we have a pure algorithm-based system that doesn't allow consideration of those unique circumstances, and I guess you can write an algorithm that's capable of doing that, but that would be immensely complicated. Then we would have a system that was inevitably producing unfair outcomes, even putting aside whether or not racial biases are built into the algorithm or built into the data fed into it. And so that would be a concern. My guess is that in the future, people will have opportunity because many people now can't get lawyers. The lawyers cost too much money. Or the cases that people have are not worth it for lawyers to handle. So my guess is that at a really basic level, we will have automated decision-making in the first instance, that people will be allowed to take their claims. A version of this is happening in England, by the way, not through computer algorithms, but by clerks evaluating the claim put together by individuals filed online. So this is a form of sort of a first cut. And if people are satisfied with the outcome, then they can accept that outcome. And if they're not satisfied, they can go further, assuming resources allow them. Mm-hmm. It seems to me as these algorithms get better, like in the tax algorithm, decision algorithm I mentioned, that is actually a sensible way to proceed. But the important element of making that acceptable is that people can opt out after they've done it, or even before they don't want to do it to begin with.
My own personal experience in the legal system was that as an undergrad, I worked at a law firm in Toronto. And basically, this was at the point where more and more firms were doing e-discovery, and that was a more common thing. It became clear that in older days, if you want to call it that, people would just bombard someone if they wanted to bully them. And obviously, this is not how the law is supposed to work, but effectively, it was clear that large firms could send boxes and boxes and boxes of documents, and the amount of work it would take to store and understand what's in those boxes would effectively bankrupt a very, very small firm. Then when I was in it, one of my jobs was basically to code some of the documents, because with e-discovery, you want to be able to find these documents really easily.
Right.
But that was the newer way to sort of bully people, it seemed, was that you would send 1 million files, and maybe they had titles or maybe they had dates, but really, if you wanted to effectively work with them, you needed a lot more information. Mm-hmm. Do we have to worry about a new way of bullying or asymmetrical power dynamics
Yes.
between small firms, for example, and big firms. Do you think it's almost inevitable that there will be new ways to bombard somebody?
Oh, I think it's inevitable. I think it's one of the themes of the book. And as I said, on the one hand, law does essential things, and on the other hand, law is pervasively influenced both in its content and operation by political, economic, social sources of power. I mean, it's been this way throughout history. I think it's one of the themes that runs through the book, and I don't see any reason to think that that's going to go away. Those with greater resources have greater access, greater use, and greater ability to manipulate the legal system to their advantage. None of the developments that we're talking about, seems to me, will make that go away. It just will be done in different ways.
Yeah. Well, do you have any sense of what those different ways might start to look like? Because I was always sort of hearing the different debates or discussions about this, and the argument was that with e-discovery, things will be at least fairly equal as long as you have a program to use, because you don't need somebody to go through hundreds of boxes and look for things, which is very labor intensive. Instead, if you have a good program and the billion-dollar-a-year lawyer has a good program, you can compete on a more fair playing field, I guess. But it doesn't seem like that's necessarily happening. So what, I mean, if anything, should we be looking out for now or on the horizon?
My general skepticism about these arguments simply is that greater financial resources has always had an ability to affect the operation of the legal system, and I don't see any reason why that. I won't say that's sort of built into the nature of law, but I will say I've not seen it not have an effect at any point of law that I focused on in this book.
Mm-hmm.
So I'm skeptical. Now, I'm not an expert on e-discovery, so I can't tell you exactly how that would work out, but I would say this: if that solves a problem in discovery, I think that's great. But there'll still be many other aspects of the system where how much money you have will have a significant impact on how these cases play out.
Okay, so that said, if people are aware of this and want to, which I think you do with your book, for example, want to make improvements to the legal system by critiquing it, by thinking more deeply about some of these issues, because it seems effectively that part of this book, the project, is to help people see what's going on and therefore potentially improve how we use law or how we interact with it. If it's always going to be a question of who has more money or who has more power, how do you stay motivated in using the law or in thinking about the law instead of just abandoning it as a sort of monopoly of the rich?
The constant theme of the book is that socioeconomic, political sources of power have an influence, but they don't always win out. And the progress of law tracks the progress of society, and more specifically, technology, culture. So much of law is changing, not all of it all the time, but much of it is being woven and rewoven through social, cultural, economic, political fights. And one of the theorists I talk about is Rudolf von Jhering, who wrote about this in the late 19th century. And his title of the book was The Struggle for Law. And I think that's a very evocative, it's a great book, very short, but very vivid written. And the point he makes is really that law is constantly the product of a struggle. And I'm not talking about pervasively. There are fundamental aspects of the law that are more or less subtle, although they're potentially changed at the margins and going forward by various things like new technology and so forth and responding to that. But one thing that is a constant is society's continuously evolving. There's social, political, economic battles in society. These are playing out in legal arenas. That is legislation. That is judging. Who gets to be judges? What legislation is passed? But also administrative law. What kinds of regulations are passed? And then who carries them out? Are the people that carry them out coming from corporations, or are they coming from public interest entities outside who are pursuing a public interest goal? The image I want to try to convey in the book is this constant contestation over law. And so it's not an image of don't bother because the rich and powerful always win.
Mm-hmm.
It's an image of the rich and powerful have significant influence, but so do other sources within society that are constantly pushing, prodding, contesting, occasionally and more often than occasionally succeeding. But it's never ending. And I think that's really, from the big picture presented, that's the idea, that it's a never ending contest. And so you don't leave the battle because you think, well, the wealthy always win out. They don't. They don't always win out. But they have significant advantages. And I think that is clear. And that very often that plays out, and then there's retrenchment, and then there's progress, and there's retrenchment. So that would be my vision. My vision is that law is continuously evolving as a result of these contests, in which sometimes there's positive change depending on your perspective, and sometimes there's retraction, and then we go forward. And we've seen many of those changes just in the last generation in both directions, progress and retraction.
Mm-hmm. And I like the way you've put that. If you were to consider any examples of that, I mean, I tend to think about the law, at least in the stuff that I've looked at and written about, in terms of civil rights and progress in that sense. But there are various ways of fighting this battle, as you mentioned. Is there anything that you find more productive if you want to challenge any legal? You don't have to necessarily be on a certain side, but if we're thinking about groups who are concerned, for example, about equality or about the representation of certain populations, are there better terrains to think about entering than others when it comes to the law?
I think the answer is that if you have a particular objective or goal that you'd like to see in law, you have to look at all of these legal arenas and try to make progress in all of them. Some of them may be more receptive to a particular agenda. Some of them may be more accessible if you have fewer resources. It all depends on what it is you're talking about. But we have concrete examples, so I can illustrate this. In civil rights terms, obviously the civil rights was a movement in the streets, but it was also a movement in political institutions. It was a coalition of different groups of people who thought that this was really important. And as a result, really significant legislation. So I want to talk about the legislative arena. One of the most significant is the Voting Rights Act. And this was specifically designed to prohibit election laws that were disadvantaging particular groups within society, specifically African Americans. Mm-hmm. The Voting Rights Act was passed, and then conservative groups focused on changing the court, the composition of the court. And this was a decades-long campaign because they thought the court had been seized by liberals, and the famous target for them was the Warren Court, and then the Burger Court, and all the decisions that they made. Well, following a campaign to remake the U.S. Supreme Court as well as the federal judiciary more generally, as well as state judiciaries, by the way, these state campaigns now have millions of dollars, and previously there was very little money in the state campaigns. Mm-hmm. So as a result, in Shelby County, the Supreme Court struck the provision requiring pre-clearance of certain states on drawing of voting lines. And immediately after the decision was passed, certain states began redrawing voting districts in a way that disfavored minority interests. Mm-hmm. So here's a single example where, on the one hand, battle was done in the streets, but also effectively in political arenas, resulted in a law. And then that law wasn't changed. It was the composition of the Supreme Court, decades later, that said, well, this provision of the law, we're going to declare invalid. It's not necessary anymore. So the law didn't change, but by declaring it invalid, the immediate response, and this was through the composition of the court changing, the immediate response was then political institutions at the state level responded by getting immediately to work to redraw districts in the ways that were initially problematic, and one of the reasons behind the law to begin with. Now, what arenas should someone concerned about voting rights fight in? My answer would be all of them. If you want to pursue this agenda, you have to fight in state legislatures, fight in federal judicial appointments, fight in Congress to get, they can pass another version of that act or another version of that particular provision that was struck by the Supreme Court. So it's not a question of which, but a question of all, and all in relation to what your resources are, where you think you might have the most receptive audience. One of the important things about the strategy of conservatives is they have been very systematic about developing the Federalist Society, very systematic about grooming people to become judges. And this is a decades-long effort. There have been several books written about it, and it's been enormously effective. Now, I guess liberals or progressives are thinking about doing the same. Conservatives have had a kind of laser focus on the court, and progressives have not. So if progressives want to do the same thing, then of course they can do the same thing. The idea of contestation through law, I think, is recognizing that It happens in every one of these arenas: state, federal, legislative, judicial, administrative. I haven't said much about administrative agencies, but administrative agencies are themselves influenced by various interests. We had, for example, Scott Pruitt, who sued the EPA, then become the head of the EPA.
Mm-hmm.
So,
And is no longer, I believe.
it was no longer. Yes, exactly. I wrote a book before this one called Law as a Means to an End. And the theme of that book was about precisely this, about how groups in society are utilizing law. The old idea of sort of law is there to keep balance in a war of all against all. But what I suggest in that book is that law itself has now become something that people seek to control and utilize in the battles themselves.
Mm-hmm.
And I think this is borne out by everything that's going on today.
It's a lot to think about and take in, and especially can be exhausting because, while I appreciate you saying that all of these arenas are important, man, just thinking about contesting things on all of these arenas is also a daunting task, but granted, not something that I would imagine one person takes on.
No, and also it's not just about law, right? We are having these contests in culture and media at every level. And the question is how you channel those into political and legal institutions that actually construct law, making law, interpreting law, enforcing law. I mean, one of the themes of this book is that law's influence by society. It's oozing through law in every pore of law is these social influences. So one need not take it on specifically in the legal context while still making a contribution. If your goals are to do that, changing the kind of television shows people watch will have an impact on altering views of the public at large, for example. There are lots of different ways to contribute to, whoever you are, your particular objectives that can ultimately find their way into law, which don't involve dealing with law in the first instance, but instead dealing with social cultural attitudes, technology, and so forth.
Yeah, of course, that's a really important thing to think about, is the way in which all of these things are connected. I'm curious if you've come across or seen misconceptions about the law, whether that's how it actually works or whether it's the way that we ought to think about it, maybe as not being connected to society when it really is so much a product of our society. If you could sort of get rid of certain misconceptions or set the record straight in some ways to a general public, are there any things that you have seen come up maybe frequently that are problematic in the way that people view and understand the law?
The most problematic thing for me isn't that people misperceive the law. I mean, I think people have generally not good information at a political level about what kinds of laws are being passed and whether that's in the interest of people supporting the politicians passing those laws. My biggest concern about law generally is that we are losing a certain level of fundamental recognition that the law has this baseline role in our society where people need to respect and support institutions that are law creating and law enforcing. Law has become politicized so much that law functions because there's a level in which people in law making and law enforcing institutions are committed to doing what law requires. If the public attitude becomes so corrosive and that law just becomes a weapon, my concern over time is that there's no respect for legal institutions. And why that's a concern, let me just say I have reassurance that this won't happen in the short run, but that reassurance is based on tradition. Law itself is a cultural tradition. The development of legal institutions is a tradition, and that tradition is resilient. So when Mueller comes in and he does an investigation, he's committed to upholding the law, and I feel quite secure about that. But when others think of him as a political actor in a witch hunt, and that's believed by a wide percentage of people, that becomes a great concern. And the reason for that concern is that these institutions need continuous support, and support both because people believe in them, but also because the people in them believe it's their obligation to carry out law. Now, getting to the concern. So the reassurance is that it's a resilient tradition. The concern is that each generation has to renew those commitments to legal institutions, both in the public generally, as well as the people who engage in these institutions from the inside. And I have studied law in developing countries at various points in my career. I worked in one. and have written about it. And that's precisely what they lack. They do not have a broad commitment to legal institutions, and in many cases for good reasons, because they were corrupt or dysfunctional. But as a result, many aspects of their society don't function as well as they could. And it's difficult to keep public officials honest. Corruption is rampant. There are many negative consequences that come from a society without functional legal institutions. So if you were going to ask me what's my biggest concern, it's that the cynicism about law has become so pervasive that we may be going too far, but we won't know until it will be hard to recover at some point.
Yeah. Do you think that it is a realistic possibility that the law or the legal system, the courts, could in America be depoliticized, or at least significantly less politicized? I mean, one of the interesting things I noticed coming from Canada to the US to work was that a lot of issues, but gun violence, for example, when there's a shooting, conservative politicians want to prevent any kind of gun legislation. Certain ones, they'll say that the liberals are politicizing this event in order to pass gun legislation or what have you, which is interesting because they're also obviously politicizing the event to prevent gun legislation. Mm-hmm. But this attack on another for politicizing the law or politicizing the courts seems to be something, as you say, is something very troubling, in the sense that if it is fully politicized, then you risk maybe having Democrat courts versus Republican courts or what have you. But do you see it as a possibility to depoliticize the legal system in America?
I don't think you ever go back. I think we're always moving forward. And by moving forward, I don't mean progress. I mean whatever historical events occur from that moment forward, they are not erased. So to the extent that politicization has occurred, I don't see how that's going to be. We're not going back to another day. The importance is that there's still a solid core of law, both in judicial decision making and in the enforcement of laws by line prosecutors. They're not acting as Republicans and Democrats. And maybe the head of the office is, and changing one agenda for another, but people carrying out the law are still committed to the law at a general level. And the same, in my view, is true of judges. So it's less about somehow erasing what happened. I just don't think it's possible. Than about everyone coming to appreciate that our entire social, legal, political, economic existence depends on functioning legal institutions, and then recognizing that there are political elements, but there are limits to how far they should intrude and do intrude on a day-to-day basis. So my concern is about the idea of thinking it's all pervasively political, which is just not true. But if people begin to believe this, that belief can be ultimately corrosive, because law is something we construct, and we construct it based on what we believe it represents. So no, I don't think we can become less political, but I do think people can come to a sophisticated understanding that law functions and it works more or less as law, and that there are political elements, but they're not pervasive in a way that makes it all politics. And that's a kind of mature understanding of what law is about. I am optimistic people will be able to understand, but we'll see. I don't know.
Yeah, we could talk for a long time about A Realistic Theory of Law. It's a really interesting book. My last question for you is where you want to take these ideas in your next project. Are you furthering some of this? Or are you moving in a new direction?
I'm working on a book about legal pluralism. It's a big theme out there. It's a theme in anthropology, in international law, and now in jurisprudence. So I'm really trying to write what I would call an explanatory text, talking about what legal pluralism is, how it's different actually in each of these different disciplines. Part of the reason I want to write about it is because it's significant in many countries working on legal development. One of the issues about legal development is that in these societies where state systems are trying to be bolstered, there are other forms of law that are much more efficacious. People can relate to them, understand them. So the situation these societies face is very different from the situation the United States faced, for example, when it was developing in terms of the legal system. That idea, legal pluralism, was in the realistic theory, but I didn't focus on it as a central focus. So I'm really trying to pull out that piece of it and show its significance today in all of these, both academic arenas, but also importantly around the world in situations trying to develop legal systems.
Sounds really interesting. Yeah, Brian, thanks so much. I know that you're busy, and spending this time talking about your work is really interesting and helpful in terms of not just obviously people practicing law or involved in the legal system would benefit from looking at this, but also anyone trying to understand what's going on, which is kind of me, who's not practicing law, but trying to comprehend how best to negotiate what we're seeing around us. And I found this really helpful for doing that. And I just want to thank you again.
Great. Thank you, Chris.
As always, I want to thank you for tuning in and supporting This Is Not a Pipe podcast. If you haven't checked already, Brian and everyone else I've interviewed has given recommendations on books you might want to look at. That's in the show notes and at tinap.org. And as always, I appreciate people listening, commenting, and telling their friends about this. It always helps if you can leave a review, and I really do appreciate it. Until next time, cheers.